the applicant state has been at pains to disavow, an agreement that has been in place for 10 years, and it's now being suggested it's not relevant. It's also being suggested that because it did not comply with the requirements of Article 102.2, it cannot be placed before this court. It's rather unfortunate that having brought the respondent state before this court, the applicant state seeks to rely upon what can best be described as a technicality. However, I begin by referencing the conduct of the applicant. The applicant has sought to invoke and obtain the most exceptional relief from this court. And it has done so, as paragraph 23 of its request makes clear, by urging this court not to permit an oral hearing. If an applicant seeks to invoke such an extreme jurisdiction to deny the other side a hearing, it is incumbent upon such an applicant to ensure that it provides a court with full and frank disclosure, that it ensures that the documentation and information placed before the court is accurate, and that it ensures that all material facts are placed before the court. As I will demonstrate, there are, unfortunately, flaws in the approach of the applicant in every respect, so far as these three fundamental elements are concerned. Firstly, paragraph 20 stressed that without provisional measures, Commander Jadhav would be executed before the court could consider the merits. Indeed, paragraph 21 stressed that there was such immense urgency that this might happen any day. And therefore, it is not surprising that when one seeks to invoke the jurisdiction of the highest judicial organ of the United Nations, indeed, the highest judicial organ that all members of civilized nations turn to, that the President issued the letter on the 10th of May, as he did, in the terms that he did. It was said in the application, furthermore, that the trial was rushed through and that Commander Jadhav could be executed summarily. The papers before the court, within the application itself, demonstrate at Annex 6 the detailed public statement made by the advisor to the Prime Minister on the 14th of April, His Excellency Sattar Aziz, that none of that is, with respect, true. There were 4 stages of the trial, 21st of September to the 12th of February 2017. The clemency process was identified clearly, the timeline, 90 days plus 60 days. What's also said to this court in the application, paragraph 9, is that the Pakistani authorities had made it clear that Commander Jadhav was not eligible for consular access, nor would he be granted consular access. The court was referred to Annex 7. Regrettably, Annex 7 says no such thing. What the applicant has sought to do is to introduce as Annex 11 an article from a newspaper, which, whatever else it may be, is not a newspaper of the record in Pakistan. But what is important to note is that there was plainly a material misrepresentation in the application that was placed before the court as to the position of the authorities of the Islamic Republic of Pakistan. Because, in fact, Annex 9 to the very same application provided a draft transcript of a 3-page press briefing provided by the spokesperson to the Foreign Office. And the court will see at page 3 that in answer to a direct question from a journalist, the Foreign Office official spokesman made it very clear that pursuant to the bilateral agreement between India and Pakistan of 2008, which India is anxious to avoid any reference to, the question of access to Commander Jadhav would be decided on the merits. The court has been given an indication, moreover, that there was some request for evidence made by the Pakistani authorities, but all that the court was given was the cover letter. in the annexures. Unfortunately, the court was not provided with the substantive material which was given to India on the 23rd of January 2017, but it has now. In the judge's folder at Annex 1, the court will see that the material comprised a cover letter which identified 13 names that Commander Jadhav had provided to the Pakistani authorities. The cover letter sought the assistance of the Indian authorities to the phone records of Commander Jadhav. It sought the assistance of the Indian authorities to bank account details. These are all perfectly reasonable, legitimate requests. The Indian authorities were provided with a copy of the first information request, the details of the allegation, Annex 1. Annex 2 was a copy of the passport. Now, interestingly, at no stage has India made any comment about the possession of a passport by an individual whose nationality as an Indian national has been assumed, we say de bene esse, but has not actually been established by the Indian authorities. The passport plainly requires explanation. There is the confession, which is in the bundle that was given to the Indian authorities, together with, significantly, the United Nations Security Council Resolution 1373, one of the most important Security Council resolutions ever promulgated in the aftermath of the horrors of the attack on September the 11th. India, no doubt, would have been fully familiar with the principles identified in that resolution, but incumbent upon all member states of the United Nations is the obligation to assist, not only in preventing terrorism, but the provision of evidence. What happened? Deafening silence, no response. What's said in the application at page 24, paragraph 50, is that the confession of Commander Jadhav was obtained after India had sought access. Somewhat ironic, because as you have seen, and as the written submissions that are before the court will make clear, the chronology is as follows. Commander Jadhav was arrested in the southern province of Pakistan, Balochistan, which is mineral rich and unfortunately has seen violence all too often. He crossed in from Iran, bearing that false passport. The position, so far as the video is concerned, is that that video was aired. That was a confession video aired on the 25th of March, 2016. So it's plainly incorrect if it's being suggested that that video was obtained after consular access was sought, because the chronology simply doesn't bear it out. What's said, in addition, is that Pakistan, at the application paragraph 28, made it a condition of consular access that the mutual legal assistance request was complied with. And pausing there, I respectfully submit to this court that the obligation to prevent and to enable the punishment of terrorism is one of the highest obligations that all member states of the United Nations are subject to. Indeed, I would go much further and say it's an obligation erga omnes. It wasn't a condition on consular access. It was a fundamental requirement that India was to comply with, and it's yet to give an explanation to this court as to why it has not. And in fact, it's simply inaccurate, if not, with respect, misleading, to suggest that the government of Pakistan and its officials had attached conditionality. What they had said, and again, this is in the annexes before the court, Annex 3, the letter of the 21st of March 2017, before judgment was handed down on the 10th of April 2017, is that the consular access request would be considered in light of the response to the mutual legal assistance request, so as to enable early dispensation of justice, so that the evidence could be provided to enable the legal process to take its course in Pakistan. Insofar as it's been suggested that the process of that Commander Jadhav is subjected to is some form of kangaroo court. It's rather bizarre that a court exists in a state which is seeking to do justice and is asking for evidence in that regard and is sharing evidence in that regard. So the position that's advanced before this court is, with respect, a sham. But what does this all get to? We saw in the request at paragraph 20 that the President was urged to act on the request for provisional measures because Commander Jadhav might lose his life any day. India generated a sense of urgency, not Pakistan. India invoked the jurisdiction of this court improperly, and as a result has now, interestingly, shifted its position as to what urgency is. We began with any day, but my friend, when he addressed the court with reference to the Avana case, suggested that it was appropriate for this court to grant provisional measures where, in the Avana and Mexico, the Avana Mexico case, the death sentence prospect was some 6 months away. Firstly, that's not correct, and second, it's not acceptable to invoke the jurisdiction of this court on the basis of imminence, any day, about to be committed, and then come to the court and say, it may be 6 months, that's enough for you. Because when one looks at the cases themselves, the 3 death sentences cases, they all relate to the use of capital punishment in the United States of America. In the Paraguay case, there was a period of 11 days before the death sentence would be imposed. In La Grande, it was the next day. And in Havana, the earliest that any one of those 54 Mexicans might be exposed to the death sentence was 4 weeks. Not 6 months, 4 weeks. And when one looks at the drafting history of Article 41, which this court, in the La Grande provisional measures case, helpfully provided an insight to, at paragraph 105, Article 41 relates to certain situations in which irreparable harm is about to be committed. About to be committed. There is plainly in that language a sense of immediacy, imminence, urgency. And 6 months plainly, in nobody's book, is imminent or urgent or immediate. The application conveniently glossed over the existence and availability of clemency, which was articulated in the advisor to the Prime Minister's public statement on the 14th of April, which was before the court, but was not drawn to the attention of the court. In the oral phase this morning, my friend indicated that action was likely to be taken before final decision is likely to be given. An elastication, at best, of the position that was placed before the court in writing. That simply will not